Mandatory disclaimer. This is not legal advice. It is for informational and educational purposes. If you want real legal advice, you should go to your attorney, pay them real money, and they will give you real legal advice in exchange. Which brings me to the next point. I am not your attorney. There is no contractual relationship between you and I. I already have a client and I'm not accepting any anyhow. Now that the mandatory disclaimer is over, let's go ahead. Hello, and thank you for joining me today. Imagine a world where you can share your most honest thoughts, your fears, your strategies, even your mistakes, without worrying that they're going to be used against you in a courtroom. Today, we're going to discuss the legal privileges that make that world possible. First, we'll discuss attorney-client privilege, then the attorney-work product privilege, and finally, we'll discuss a situation where these two privileges come in play, an attorney-led investigation, which you could use when something has occurred that might result in litigation. These attorney privileges are the hidden shield that allows us to speak our truth completely and courageously. Why are these privileges so important? Well, in the heat of litigation, every word counts. It keeps our conversations, those frank, sometimes blunt discussions between you and your lawyer, safely away from the opposing counsel and the jury. It gives you the freedom to admit what might stink privately and to explore options without the glare of public scrutiny. This confidential space is where real strategy is born. Now, let's briefly walk through the journey of civil litigation in the U.S. After all, I'm a U.S. attorney, so we'll be focusing on that. Picture is a bit of a roadmap. We'll start with the pleadings, move on to discovery, then go to trial. We'll reach a verdict, more often than not a settlement, and if needed, proceed to appeal. And every step is designed to uncover the truth, not only for you, but also for the opposing side. And throughout it all, the attorney-client privilege plays a crucial role in protecting your most candid insights. The part we're concerned with is discovery. Discovery's like turning on a bright light in a dark room. It's the phase where each party searches for every piece of evidence that both sides need to know. It could be asking questions, which in written form they're called interrogatories, and in verbal or videotape form they're called depositions, or discovery can be, and often is, asking for documents, including emails. In the United States, discovery is extensive, and it's up to the parties of the lawsuit to do their own searching and investigation. And the other party is obliged to provide them with the evidence, documents, or answers to questions that have been asked. There's stiff penalties for lying or for hiding evidence. Now, compare that with Europe, where discovery is much more restrained. It's with limited resources. It's a completely different philosophy. There are three purposes of discovery. One is finding out what you don't already know and need to know. And two, catching other people in lies or obtaining admissions, whether that be turning a witness or setting some type of code of conduct for how questions will be asked and answered. And three, preserving testimony. For example, if you have an elderly or an infirm client, or you have an employee that might flee the country. As a client, you really don't need to know too much about the tactics of discovery, and there are a lot of them. And I'm not here to turn you into a discovery expert. You'll pay your lawyer to know how to handle the trial. This talk focuses on the basics the client needs to know, but it is understood that some conversations need to remain private. All those frank, sometimes blunt discussions between you and your lawyer, in both the US and the EU, through maintaining attorney-client privilege, or as they call it in Europe, the legal professional privilege. That means you're ensured that your most confidential exchanges need to be exposed to the opposing counsel. So how exactly do you call upon this privilege? Well, there's four ingredients that are critical that you must have to have the privilege. One, it needs to be a communication, an exchange of ideas or facts, whether spoken or in writing. I just can't take a bunch of documents in a warehouse, slap a label on them that says privilege. It needs to be an exchange of ideas between the attorney and the client. And that's number two. The communication must be directly between you and your lawyer. For companies, the client is the employee, and the employees are considered to be part of that client. Remember, if there's part of an email chain without the lawyer's participation, those parts may not count as privilege because you need to have it between the client and the attorney. Three, you're doing this communication to obtain legal advice. You want to use words in your communication like, I would like to ask your advice as a lawyer. I would like your legal advice. Simply copying an attorney on an email chain is nowhere near good enough. They need to be an active advisor. And the fourth, the communication is intended to be confidential and private. The idea is that it's a private conversation between you and your lawyer. Limit who's on the CC list and avoid forwarding that emails to anyone outside your circle of trust. I strongly suggest marking your subject line with something like attorney-client privilege. Now, the words aren't magical, but they send a clear signal both to people and to digital systems that this is confidential territory. But let's be clear. Privilege isn't a magic cloak that covers every fact. There's a dangerous myth that if you tell or give your attorney something, it's automatically protected. And that's just not true. Let's say you're having a meeting with your attorney and mention that an engineer came to you. They're quitting because they hated the company so much, and they intentionally put a defective part design in the product, and now that product has gone on to manufacturing, and it had cost the company millions to fix this defective part. You, as CEO, decided it's just better to leave the defective part there and hope for the best. And now the company is in a class action suit for the defective product. Well, that's bad, but will the privilege protect you? In court, the opposing attorney cannot ask, what did you tell your lawyer? They cannot ask, what advice did your lawyer give you? But they can ask, did the engineer tell you about this defective part? And then you can choose to lie or tell the truth under oath. I suggest you tell the truth. Can they call the engineer to the stand and ask, did you tell the CEO that this part was defective? Yes, they can call that. Even though you talk with your attorney on the subject, the facts of what the engineer knows is something that they can be learned by not breaching the confidentiality between you and your lawyer. Attorney-client privilege doesn't shield all instances of a version of a fact from being learned just because you told your attorney. Think of it as a roadblock. The attorney-client privilege stops them from driving down one road, but if they can get to the destination by traveling another path, that's okay. Let's say you gave your attorney a document or a report from the finance group on how much it would cost to stop the production line, redo the parts, scrap all the existing versions of the product that are defective, which, by the way, that's pretty strong evidence that you knew something was up. Since you gave that document to your lawyer, is it privileged and undiscoverable at trial? The answer is, of course, no. The report is not a communication between you and the attorney. It was between you and the finance department. It was not legal advice. It was business advice or information. And the fact that you later gave it to your attorney doesn't matter. You would have to produce that document if asked for it during discovery. Now, if you had come to your attorney ahead of time and asked them what to do, and they said, the fine for fixing this part is likely to be $5 million, but the cost of fixing it is going to be $20 million, I suggest not fixing it and paying the fine. Well, that's legal advice, and opposing counsel would not be able to ask, what advice did your attorney give you? That advice would be privileged. Let's take another less dramatic example. A client might give the attorney details of a bunch of transactions with another business over the past 10 years, including dates, costs, purchase orders, all that kind of stuff, to help the attorney draft a new contract with the business. Now, in future litigation, the client would not have to answer any questions about what was said or by the attorney or what contract language the attorney recommended. But the client could not refuse to give up those records, including the information of the 10 years of prior transactions, simply because those facts were discussed with the attorney. The bottom line is you can't launder unpleasant truths through privilege. And of course, your lawyer can't tell you how to commit a crime. They can talk about your defenses after you've committed the crime, or they can tell you how to avoid committing a crime. In fact, that's a lot of what they do, but you don't get to maintain the privilege so you can be a better criminal. This is known as the crime fraud exception. And fraud's a crime, but apparently they were worried enough about it to call it out twice, specifically in the name. Another instance. In Europe, lawyers are treated as specialists, like accountants or auto mechanics. They're called in for specific questions. In the US, lawyers, especially in-house counsel, are seen more as business advisors. They're usually part of the leadership team. And this creates some uncertainty where the privilege ends and where it starts. Communication for legal advice is privileged, but communication for business advice is not. So the lawyer and you needs to be aware of their role in the conversation. You can end up with a discussion that is partially privileged and partially not. Privileged for the legal advice, but not for the business advice. So how do we keep our communication secure? Well, the obvious answer is to only have verbal, non-recorded communication. The old adage, say it and forget it, write it and read it applies. If you truly want to keep a conversation secret, have it in person or over an unrecorded phone or video chat, where what is exactly said is completely unrecoverable once that conversation ends. Often, this is a good way to have your client feel comfortable enough to tell the attorney the unvarnished truth of the matter. If you do need a conversation memorialized, you can always write a summary or minutes email afterwards to the attorney or the client. Keep that summary between the attorney and client, and it keeps that under the scope of the attorney-client privilege. Also, in redrafting that conversation afterwards into a summary, it gives you time to consider and to rephrase things in a more professional way and better way instead of going into detail. One thing you can do is just allude to the matter discussed enough to jog the participant's memory. Don't go into all the facts that you don't want explored. Aside from the summary email, in every written or verbal videotaped communication, you should think about how this is going to play to a jury when they blow it up to an 80-inch monitor in the classroom, in the courtroom. There are plenty of cases where the writers of an email tried to posture and be cool badasses only for their words to make them sound like arrogant bullying teenagers when it came to trial. So even outside the idea of privilege, that's good advice. So how do we keep our communications via email secure? Well, first, limit who's included on every email. Only include those who really need to be involved. Don't use blind carbon copy or BCC or forward the email without an allowed purpose. And for example, that would be reporting to your superiors. If you're in a corporation, use your emails, specifically Outlook security settings, to prevent forwarding, and establish solid document retention policies to automatically delete sensitive material when it's no longer needed. But remember, all those nifty no forwarding features in email and Outlook, they only work when they're on your company servers. Once your email has left the company and gone out into the wider internet, those restrictions and settings are lost, and the email can be forwarded by and to someone else. Which brings us to the second point. The communication is between the attorney and the client, meaning the company, not the attorney and some contractor or some supplier. Keep third parties out of the privileged communication, or have those conversations as part of an attorney's investigation, which we'll talk about later. To maintain the attorney-client privilege, only the attorney and the client can be in the conversation. The classic two examples of losing the privilege due to adding third party is adding a consultant to your email chain. I know the guy works next to you, he sits in the office next to you, but if he's not part of the company officially, he's not the client. Or have a conversation with your lawyer in a public place, like a restaurant or a crowded elevator. If that conversation could be overheard by a third party, then it's not going to be privileged. Third, one of the tools used for modern discovery are software programs that scan a company's email and file servers looking for keywords. Both keywords for what is relevant to the litigation and needs to be produced, and things that are supposed to be privileged and do not get produced. And you want to include keywords that tell the software this email or file is privileged and is not given to the other side. You want to indicate to the world and to any e-discovery software that this message is to be covered by the privilege. So put words in the subject line and the body of the message like attorney-client privilege, privileged and confidential, attorney-client privilege communication, or something similar. The words aren't magical, but they should indicate in a short form to the e-discovery program that it's supposed to be privileged. Fourth, keep the communication focused on legal advice. If you're asking about both legal and business advice, try to separate the matter into two clear portions of the email. As an example, legal advice might be a lawyer explaining implications of a clause of a contract, and business advice is deciding if signing the contract is a good strategic move for the company. As I said, lawyers in the US are often in the leadership team, and this line can get very blurred. So I suggest starting a new, clearly marked email chain when the conversation turns from business questions to actively seeking legal advice from your attorney. It's understood you'll need to share some facts and prior discussions with your attorney, and those may still be discoverable. I can mention that you should only forward email for allowed purposes. And what are those allowed purposes? Well, since the client's the company, those purposes are things necessary to manage the company. And the obvious example is informing your bosses what advice was given and what decision was made, or asking them for a decision. The higher up the manager is, the greater the assumption that they're acting as the company and therefore are the client. You can also forward down the chain of command to relay a decision and to provide guidance to underlings. But the more you move down that chain of command, the greater the presumption the receiver is not considered the client. In both cases, you want to emphasize the confidentiality and secrecy of the message. And feel free to include the attorney-client privilege subject line we've talked about. Everyone should know to keep these things a secret. If you need to tell a large number of people, for example, communicating to a department, realize that the department-wide email is not going to be privileged. So limit what you say to only things you wish to make discoverable, and feel free to tell them, talk directly to the lawyer if you have any questions. We talked about the company being the client. A large number of people in the company creates a wrinkle that the attorney should know about. In order to strengthen the privilege when talking to middle or low employees, i.e. not those in the C-level suites, the Supreme Court in Upjohn versus United States has devised a warning, not too different from the Miranda warning, that should be given before an attorney talks to a lower level employee. During communication, an email interview, etc. Company's lawyer should explain that the lawyer represents the company and not the individual employee with whom the lawyer is dealing. This is intended to ensure that the employee understands whose side the attorney is ultimately on, which is not theirs, it's the company. And that the company, not the employee, can waive the attorney-client privilege at any time and disclose the contents of the conversation between the lawyer and the employee, even if that employee objects. It makes sure that the employee knows where they stand and assures they don't think they have more rights than they really do. When we're facing litigation, the stakes are high. One misstep can mean losing that crucial privilege. The number one way to lose that privilege is by disclosing confidential information to a third party. Whether you do it accidentally or intentionally, you'll have waived and gotten rid of your protection. Now, we've talked before about how the client is the company and no one else, not suppliers, integrated contractors, consultants. They should not be included in the privileged communication. Even an NDA or confidentiality agreement won't help you here. It doesn't matter if the third party promised to keep things secret. You still broke the seal of the very special relationship between the attorney and the client. After all, it's called the attorney-client privilege, not the attorney and close friends privilege. And then as an aside, NDAs don't prevent people from testifying at trial. Most states have laws against this, and even if they don't, the judge will compel the testimony, creating an exception to the NDA if needed. Let's talk about something called selective waiver. Some states allow for a selective waiver where you can waive privilege for one litigation or a government agency, but not for everybody else. And like fair use and copyright, people get all excited about this. They can let them do whatever they want, but it doesn't. Most states don't recognize the idea of selective waiver. You aren't allowed to tell anyone, any non-client, and expect that secret to stay there. The courts will remove the whole waiver for everyone. You can't pick and choose who you tell. But I want you to note, this ban on selective waiver is based on who, not what. For example, if you wish to make an opinion letter from your outside counsel, say your defense is that you did what your attorney advised and you thought you were following the law, you can waive that privilege for that letter and not waive the privilege for all other communications between you and your lawyer. But that opinion letter is now public for everyone. You choose what you make public, not to whom you make it public. So maintain tight control over every communication and always think 2-3 times before forwarding sensitive, privileged information. Now, sometimes you have no choice. Government agencies will ask you to turn over data or waive your privilege, and they will rarely be able to demand you do it. But like The Godfather, they're going to make you an offer you can't refuse. This example is outside of attorney-client privilege, but it gives you an idea of how the government operates. In 2001, the CEO of Quest, which is a large telecommunications company, Joe Naccio, was asked by the NSA to allow illegal surveillance of Quest customers. That was the offer he couldn't refuse. Joe refused. The NSA responded by canceling hundreds of millions of dollars in Quest government contracts, causing Quest stock to fall from $38 down to $2. And if that 95% drop wasn't bad enough, then the SEC indicted Joe for misleading stockholders because he had said Quest was likely to continue the contracts, which at the time he said it, Quest was likely to continue the contracts. Joe's now serving 6 years, or has served 6 years in federal prison, and it was ordered to pay personally $71 million in fines and restitution. Look, I doubt the government's going to be so dramatic, But even the smaller agencies know how to make an unrefusable offer. When I worked for a nuclear power reactor company, we were often told to give up confidential information or our application will be rejected. And you give them the information. You try and negotiate as best as you can, but you have to give it up. And the compelled nature of any waivers, even with an NDA in the government, which doesn't really work, but it's better having it than not, will preserve your privilege. I had mentioned that the easiest way to waive your privilege was to share the communication with a third party. Yet, even the best of us can err. Mistakes will happen. If a disclosure occurs, the success of the remedy is often in the speed and the formality of your response. Success ultimately depends on the judge's mood, but you're much more likely to be forgiven for mistakes, and you'll almost never be forgiven for intentional disclosure. So under the U.S. Federal Rules of Evidence, Section 502, if disclosure was inadvertent, maintaining disclosure will depend upon how adequate and complete was the formal procedure or policy that your company had to prevent disclosure. You need to look like you take the secrecy of the communication seriously. This was just an unfortunate mistake and not chronic sloppiness. 2. How quickly did you react to correct the disclosure? If an inadvertent disclosure occurs, act immediately. Try and correct it. Ideally, your rapid response or attempt can mitigate that damage. Ask the receiver to delete the communication and emphasize how secret it is. Try and claw back that mistake. Judges will consider how quickly and effectively you attempted to reclaim confidentiality. Unfortunately, state courts often take different approaches, and there's 50 different types of state courts. There's actually more than that. But remember, once privilege is waived, even in one conversation, chances are relatively high you're not going to be able to regain the privilege. So prevention is always better than a cure. In our global business landscape, things get a bit complex. US and European courts approach attorney-client privilege differently. The largest difference is that in the US, both in-house and outside counsel can benefit from it. Whereas in Europe, it's usually reserved just for external attorneys. But will different countries respect the other country's view of privilege? It's no surprise, as I found out when my son applied to European universities with his high school credentials, everyone likes their own rules and want to ignore the other side's rules and benefits. In short, the US often grants privilege to European attorneys, but European courts try to limit US attorneys' privilege based on Europe's system. More specifically, back to the US. The US courts have taken 3 different approaches for when they will grant privilege to an EU attorney or client. Depending on the court's going to look at either what were the expectations of the attorney and the client, did they expect they'd benefit from privilege, and if so, they'll often be granted it. 2, what was the subject matter of the communication? If it was legal advice, courts in the US tend to grant the privilege to the communication. And option 3, they may just apply the most protective and applicable privilege rules they can, which is usually the United States. Conversely, the EU is hesitant to grant attorney-client privilege. In fact, it's highly unlikely that an EU court will recognize the privilege of a US lawyer practicing in the EU, but not admitted as an EU lawyer, whereas a US court likely would. So for example, if you were an EU company or manager and asked me as a US lawyer for legal advice, if the case was tried in the US, we would likely have the attorney-client privilege. But if the case was tried in the EU, we would not be granted the legal professional privilege. Now, the good news is Europe's form of discovery is much less invasive. So losing the privilege in the EU is not as large a problem. And in arbitration, the rules just vary even more. The attorney-client privilege is going to be based on whatever the rules of the arbitration body you chose when making the contract. This means understanding and respecting these differences of the jurisdiction you're litigating in is critical when you're dealing with international matters. Another layer we must consider is the work product privilege. Think of it as a coach's playbook. Everything your attorney creates in anticipation of litigation, such as notes, opinion letters, is kept confidential. This protection is vital because it allows the legal team to prepare without tipping off the opponent. It's all about maintaining that competitive edge right up until the day of court. And this is different from the attorney-client privilege. Attorney-client privilege is a communication between the client and the attorney. The work product privilege is not about communication. It's based on the attorney doing work. I know it's shocking, it was right there in the name. And preparing documents. And those include videos and notes and reports to you. Sometimes documents communication may be protected under both types of privilege. For example, reports to you. So what are the requirements of the attorney work product? Well, work product requires 3 things, 2 of which are easy and obvious. The other one requires some thought. 1, it must be the work of an attorney or their subordinates, like a paralegal, a junior attorney, something like that. It needs to be tangible material or electronic equivalents that the attorney actually produced. Those two are easy. The one that's most often argued over is the third. It must have been made in preparation with a reasonable eye towards litigation. It's not enough to have some tenuous possibility the litigation may arise someday, nor do you need to have actually been sued. But the possibility of litigation must be reasonably foreseeable, and the attorney needs to be working to address that concern. So it would include notes taken during an investigation or a meeting, opinion letters, things of that nature. Now, there comes a time when something has gone seriously wrong. Most often, it's an HR matter or a compliance breach. Sometimes it's a product safety recall or some other unfortunate event. When such an issue arises, investigations occur, and it must be handled with the utmost care. There are multiple ways to run investigations, but if investigations are handled by your legal staff, portions of the evidence uncovered may be covered by the work product privilege or the attorney-client privilege. Having the investigation team be led by in-house or by outside counsel gives that team the presumption that they are working in a legal capacity, whereas having the team be led by a business manager creates a different presumption, a presumption that does not shield the work being done from discovery. The team may and will ultimately report to a business manager, but the team itself should look like they're functioning as a legal group. The investigation process should be clearly defined as being in pursuit of a legal purpose and preparation of potential litigation, not just business concerns or management or reducing possible costs. Now, as I mentioned earlier, HR and compliance departments frequently conduct investigations, and they should have existing playbooks beyond what I'm going to briefly touch upon here. In fact, you might want to consult with them before starting an investigation for other purposes, meaning non-HR purposes. But in the cases like engineering issues that don't commonly face investigations, I'm going to briefly discuss the procedure here. First, you assess the legal situation, both its validity and severity, and perform any necessary immediate actions. And be careful not to publicly admit any fault. Don't let your PR team cause you litigation damage later. Next, create a plan for the investigation, form a team. If this is in light of potential litigation, have the team be led by an attorney. Make sure the plan documents indicate that this is occurring in light of potential litigation, so it creates that presumption of privilege. Third, conduct the interviews and collect evidence. The facts themselves will likely be made discoverable because, once again, you can't launder bad facts because of privilege. However, a lot of the initial employee interviews can be shielded, and it'll get you ahead of any litigation knowing what someone might find. The employees may likely be later deposed, and they'll be asked questions by the other side. And courts will divide up tasks and generated documents into business and legal related topics, and they'll grant the privilege accordingly. And fourth, review the evidence, make a conclusion or recommendation, and then prepare a report or opinion letter to upper management, that is, the client. And this document will be privileged under the attorney-client privileges as legal advice between a client and their lawyer. Note, if the opinion letter is useful in litigation, for example, to disprove that the company willfully infringed on another's IP, you could always waive your privilege to that letter and use it in your defense. If the opinion letter is not helpful, you just maintain that privilege and it remains secret. It'll just sit there in the drawer in your office. And then finally, you should always implement corrective actions, if any. One of the most important things in investigations and maintaining both the work product and attorney-client privilege is secrecy. To keep the privilege, you need to keep things secret between the attorney and the client, or just to the attorney in the case of the work product privilege. The fewer people that know privileged information, the less chance they're going to leak it and waive your privilege. Now, there's also non-privileged reasons for secrecy, obviously. For example, it avoids any retaliatory action against an interviewed employee. It keeps control of the information. You're going to want to keep documents secure and require employees to speak only with counsel if a related issue comes up. As we bring this discussion to a close, let's remember, attorney-client privilege and its sibling, the work product privilege, aren't merely a legal formality. They're the key that empowers honest dialogue, sharp decision-making, and ultimately strategic innovation. Protecting your confidential communication isn't just about avoiding exposure. It's about keeping your ideas and your strategy secure in an unpredictable world. Thank you for sharing your time with me today. I hope you walk away with a deeper understanding of how vital it is to guard your confidential conversations and to use these practices as a tool for strategic advantage in every facet of your work. Thank you.